Herkese tekrar merhabalar. Tabii en zor oturumlar genellikle öğleden sonra başlayan oturumlar oluyor bu tip toplantılarda. Sabahtan çok kıymetli hocalarımızdan aslında Çocuk Adalet Sisteminin geleceğine ilişkin bazı perspektifleri dinledik. Ama Türkiye'de hala eksik olduğumuz konulardan bir tanesi çocuk adalet sisteminde onarıcı modelleri hayata geçirebilmek. Biz UNICEF olarak çok yakın zamanda bir küresel tutum belgesi yayınladık. Çocuk adaletinin geleceği ile ilgili, çocuk adaletini yeniden hayal etmek başlıklı. Orada 6 tane çok bütün hükümetlerden, bütün devletlerden bir takım taleplerimiz oldu. Bunlardan en öne çıkanı bütün her türlü ceza infaz kurumunun ve her türlü hapsedilmenin çocuklar için ortadan kaldırılmasıydı. Ama oradaki isteklerimizden bir tanesi de bütün çocukların aslında onarıcı modellerle gerektiğinde adalet sistemi dışına çıkarılması ve onarıcı modellerle aslında kendilerine uygun şekilde bir muameleye tabi tutulmalarının sağlanmasıydı. Bu çerçevede bugün bize uluslararası ilkeleri anlatacak çok kıymetli bir konuğumuz var. Kendisi Doktor Annemieke Wolthuis. İsmini ve soyadını defalarca tekrar etmeme rağmen ancak bu kadar telaffuz edebiliyorum. O yüzden kendisinden özür diliyorum. Bu konuyu da daha önce konuştuk kendisiyle. Kendisi bir çocuk hakları uzmanı, bir araştırmacı. Bu konuda eğitimler veriyor ve aynı zamanda bir arabulucu. Ana çalışma alanı onarıcı adalet ve doktorası da bu konuda. Ağırlıklı olarak genç adaleti, çocuk adaleti, çocukların insan hakları alanlarında çalışıyor. Ve bütün bu özelliklerinin yanı sıra birazdan kendisi de bahsedecektir. Hem Avrupa Onarıcı Adalet Forumu Başkan Yardımcısı, aynı zamanda onarıcı adaletle ilgili dergilerde editör kurulunda yer alıyor ve Rotterdam Mahkemesi'nde de yedek çocuk hakimi. Yedek çocuk hakimliği müessesesi ne demek? Birazdan ondan da bize muhtemelen bahsedecektir. Ben daha fazla sözü uzatmadan kendisine sözü bırakıyorum ve bugün uzaktan da olsa aramızda olduğu için bir kez daha teşekkür ediyorum. Söz sizde Sayın Annemieke Wolthuis. Buyurun.
Merhaba, and thank you very much, Juktan Kosidirum. It's also for me difficult to pronounce this right, I guess. But thank you very much to UNICEF and also to the colleagues from the Turkish Bar Association for inviting me to this important event that you're having on the future of child justice systems. I'm indeed working also for a long time already in the children's rights area. And from different positions, currently as a researcher and trainer and mediator in the field of restorative justice and child justice. And I'm also a substitute youth judge in the Court of Rotterdam, as just was pointed out. That's a unique system here in the Netherlands, that people working in different law fields can also become a substitute judge, doing court cases only once a month in the multiple chamber together with more senior judges. And that gives me also a different insight from court cases. And I also, in that position, I try to refer cases to mediation and restorative justice possibilities. Because that is what I'm going to talk about with you today. I'm going to share my PowerPoint. Let's see if that works. Yes. Can you all see this?
Yes, we can.
Good. Okay. Just I launched a new book recently together with Tim Chapman, the current chair of the European Forum for Restoration.
Birlikte.
Sanırım sesle ilgili bir problemimiz var. Bence bozmayalım. Sanıyorum kulaklık sayımız eksik geldiği için tercümeyi vermeye çalıştık ana şeye, ama eğer mümkün olmayacaksa olan kulaklıklarla idare edip sonra ben özetleyeceğim anlatılanları. O yüzden
Differently. We just try without the AirPods then. Can you hear me now?
yes, we can hear you. Please continue, Annemieke. Sorry, we had a problem with the sound. Now I think it is sorted out.
Yeah, maybe it's also due to my AirPods. I just switched. Okay, then I continue with sharing the screen again. So can you see the book picture again?
Yes, we can. Please go on.
Yeah. So it's also Cedric Cousteau from Terre des Hommes who also joined in this book, and he was in contact with some of you before. So it's important that we are quite a community in this field of child justice and restorative justice. Just to explain a little bit more where I'm coming from, I would like to say a few words about the European Forum for Restorative Justice. I'm in the board of the forum, and we are together with many organizations and individual members in Europe and beyond, working towards bringing a better access to high quality restorative justice services. And we want to make that reality in any time and in any case. So our slogan today is every person in Europe should have access to restorative justice services at any time, in any case. At the Dutch national level in the Netherlands, we are also working on restorative justice. My organization exists now 11 years. We are an innovation and knowledge center, and we try to lobby with our politicians, with our ministry about more acceptance and, of restorative justice, to add research, to improve theory and practice. And we stimulate the use of restorative justice also through our Restorative Justice Academy. We give trainings and provide other education. What will I share with you today? I will first start with a mediation example. Then I will go back to the basics of restorative justice, especially for the persons who are not so aware of restorative justice yet. What is important in the field of laws and regulations, also when you look at international human rights standards. What can be or is the role of a lawyer, your work in this particular field, and of the judiciary. And I will share a few insights from the Netherlands in how we work. And I hope there's then in the end still time for questions and answers. Yeah, one of the cases I did as a mediator is this one. I of course changed names, but Marco, a boy of 16-year-olds, and his girlfriend, they went to see a movie. And when they were in the movie theater in the cinema, they were harassed by some boys sitting behind them. And they were throwing popcorn and candy, and they were making very much noise. And when Marco said something, they got in an argument. After the movie, one of these guys was waiting for him and started kicking. And then Marco got terribly mad and took out a knife he had in his jacket, and he stabbed actually the Davy, the other boy who kicked him, who really started bleeding heavily. An ambulance had to come, and he was rushed to the hospital. And Marco he ran away, went home, but of course the police found him, and then an investigation case was started, and he was sent to a correctional youth detention center in the Netherlands.
We call them forensic institutions, but they are closed settings. And then the question is, would you send such a case to mediation, victim-offender mediation? Would you consider a restorative justice approach appropriate in such cases? If you think about your situation, your daily work, and how should that be done? And also maybe if you can think a little about what the needs of Marco and the EV would be after what happened. I'm not going to go in depth. You don't have to answer right now. I will come back to the case study later in if and how it was dealt with in the Netherlands. But I want you to think a little bit, what kind of cases would you think are?
Salonumuzdan bu zor soruya cevap vermek isteyen var mı? Vakayı aynı zamanda çıktıların ikinci sayfasındaki en alttaki slaytta da görebilirsiniz. Ama kolay cevabı olmayan bu soruya cevap vermek isteyen katılımcımız varsa buyurun.
Sure.
Ben kimseyi görmüyorum. Herhalde gönüllü yok. O zaman cevabı yine işin uzmanına bırakalım. Buyurun Anemika Hanım.
Okay, then I continue first of all with is the translation working okay still? Because I hear myself. Okay, I just continue. Let's see. Going back to the basics, what is restorative justice? We often state that criminal justice is about the offense and the offender. And when we talk about restorative justice, the harm is central. We in the Netherlands, we developed this restorative justice triangle. It's about bringing victim, offender, and community in contact. And the idea is to find solutions for harm that has been done by criminal behavior or by another conflict. And there are many different definitions existing, but this is the basic that combines the work in restorative justice. What does a victim want? He or she wants to know, why me? Why did this happen to me? So it's a bit about recognition, sometimes about empowerment feelings. I want to feel strong again, but also questions about compensation, material, immaterial, and ideally people feel like I want that things are restored. The offender, he or she can feel also guilt and shame, and also has questions of. Can be even similar questions like, what did really happen? What did happen with the other? What did happen to myself? But it's also an opportunity, if she steps into a restorative approach, to take responsibility. And finally, also to work towards resocialization. And the community, that's a bit more a difficult concept, of course. That can be the small community around a victim and an offender. But it can also be the larger community. If you have a fight on a marketplace, there are many bystanders who also can see it, who can maybe feel harm themselves. The cafe owner on the corner, it has also problems because all the people are walking away. If the community is also attacked in a broader way, also the mayor can play a role, you know. So there are different kinds of community which can be or become involved after a criminal offense. And what can a community do? They also have needs and commitments to take. So making good can be what a municipality wants or a mayor wants, and they also want to restore the peacemaking function, what we call this. So restorative justice is really a contribution to meeting individual needs and promoting safer societies. Yeah? And it can often not be seen as a self-standing contributor to fulfilling peace again, but it can be part of a process. In a nutshell, we work along values. Yeah? In restorative justice, it's about doing justice.
Annem İlke Hanım'ı bir saniyeni kessek tercüme sanıyorum tercümede bir sıkıntı mı var kulaklıkta? Kulaklık şu anda tercüme gitmiş. Bir saniyesini rica ediyoruz kendisinden. Onu bir çözelim. Evet, sadece benim ses geliyormuş.
Okay. Is it now better?
Şimdi tamam. Thank you. Please go on, Annem İlke.
Okay. I'm sorry that didn't work. Maybe something was disconnected here. Now I.
No, it's on our side. No worries, it's on our side.
Okay. Thank you. Also, solidarity is important, and taking responsibility, as I just mentioned, using respect towards the other party, and talking about the truth, finding truth together by sharing stories, actually. We have different practices. Restorative justice is about victim-offender mediation, but also if you bring together the larger network around people, you can talk about a family conference, family group conferencing you may have heard of, and restorative circles if there is a whole community involved. There are different methods, direct mediations, also indirect, when for example, the victim does want to hear from the offender but does not want direct contact, then also the mediator can actually give messages back and forward. And the basic principles are that it should be voluntary. Both parties should step in, and on a voluntary basis. You need to have trained facilitators, and important is also a solid preparation. And within the sessions themselves, it's also important that there is mutual trust, that everything is private, and that they only share with the outside world what they decide together. And mediators should be impartial and have attention enough for both parties. The applications of restorative justice are, first of all, and that is what we talk about today, more in the criminal justice field, but also in civil society. There are many other areas where restorative justice can play a role. In education, in schools, for example, we see more and more peer mediation coming up. In the Netherlands, we also work with youth courts in secondary schools. Within families and youth care, you see a lot of restorative work, but also within organizations and in neighborhoods. I am myself also a neighborhood mediator, and this morning I followed a training on cultural sensitivity in neighborhood mediations, also a very important area of work in the pre-phase before things escalate and are not yet a criminal case. Restorative justice is not only an interesting movement that started by individuals or organizations, it's really also a human rights issue these days. If you look at children's rights, it's also integrated in how we want to deal with child victims and child offenders. I go back to the UN Convention on the Rights of the Child. That is a document of 1989. It does not yet use the wording restorative justice, but it breeds restorative justice ideas and values. And in the later days, after 1996, every UN document that was produced on this particular issue of children's rights and criminal justice. The wordings were included, and we can also have a look at the general comments made by the Committee on the Rights of the Child, and the latest one on child justice is number 24, really says that restorative justice should be seen as a priority in the reaction on crime committed by young people. So there are several articles and additional rules that can be mentioned, but there are also more specific human rights instruments that are dealing with restorative justice. You may have heard from the Council of Europe recommendation 2018 that is concerning restorative justice in criminal cases. You may have heard of the United Nations basic principles on restorative justice practices. There's also a handbook made by the United Nations to work on implementation of these basic principles. At the European level, we have the very important Victim Directive of 2012. That directive had in the Netherlands, for example, an important role in the further establishment of restorative justice. It was then in that period integrated in our criminal law procedural code, and that is a binding instrument. So we had to change the practice and regulations in the Netherlands. And then I also mentioned this other important EU directive on procedural safeguards for child suspects and accused persons in criminal proceedings, which also mentions the importance of restorative justice. An important question we always are asked in this field is, it sounds all interesting, does it really work? Is it good for people? Is it also evidence-based? And indeed, meta studies show high satisfaction rates, first of all, but more important, that the feeling of justice of people taking part increases. They are taken more seriously. They feel they can take responsibility in a sense which is useful for them. What counts often for governments is, of course, that it creates less recidivism. So people tend to reoffend less when they have the other API, so to say. It can be cost effective on the long term, normally, if you make sure that through this restorative justice approach, less people get imprisoned, but and reoffend less, that helps. In that sense, it's also important to mention that people who go through such a procedure often say they can close their case. They can start fresh, a new beginning. And what I would like to state as well is that it's possible in all kinds of cases. If you look around in Europe or beyond, then it is used also in cases of homicide, of terrorism, even in sexual violence or domestic violence cases. And you understand, of course, that in these situations, you need to have a lot of preparation, do it really well, and also fit with standards and regulations in that particular field. In the field of domestic violence or intimate partner violence, I was also involved in a 2-year European project, and we developed there also minimum standards in how to do this well and right. To go back to children's rights, if you look at the United Nations Convention on the Rights of the Child, of course, fair trial and a special child-oriented approach are important. We have there the pedagogical objectives. Children should be able to learn from their mistakes. And you know about the best interest of the child, of course. They suggest that the minimum age of criminal responsibility should lay 14. In the Netherlands, we are not doing that well. Our age is 12 here, so also young people 12 or 13 years old, they can be sent to youth detention here in the Netherlands. Does not happen that much, but it can still. And the Committee on the Rights of the Child has asked us several times to change this. So far, our government and ministry did not do so. The role of parents is, of course, more important when and the evolving capacities of children themselves. They are, through the convention, seen as subjects of rights, but these rights go up when children grow older, of course. We need to work towards child-friendly proceedings and child participation. You look at Article 12 of the UN Convention, a very important right. If they are dealing with court cases, and you are all familiar with that, then they need to have a say themselves. Also, child hearings should be used and also tailor-made for their situation and they understand. Diversion should be a first choice. If children make mistakes, if possible, they should not enter the criminal court, but police referrals and other possibilities should be used first. And detention should be used as a measure of last resort in the shortest appropriate period of time. The focus should be also on restoration and reintegration, and we should really take care of victim protection, just to reiterate those important principles. Child victims and child witnesses have also gained more position within the court systems, and there are also resolutions and also European standards that are actually voting in favor of also using restorative justice in this sense. And I just mentioned here a particular article of this ECOSOC resolution of 2005 for you to have a look at later. If we use restorative justice with young people, then it's also necessary to review them in the light of children's rights, because there are risks. If you put young people together in a room with adults, there is the risk of another form of abuse. There are power differences, so you should take those issues into account. And there's also research that if you use restorative intervention, that things can go wrong. And Tim Chapman, my colleague that I mentioned before, he wrote in our new book also research that showed where it can go wrong, but he also poses possibilities and information on what is needed to make sure that it does not go wrong. And those crucial aspects, and I also write them in my research, are proper information sharing from the beginning, a solid preparation, take the children seriously, take your time to prepare them, involve parents or other caretakers, and a lawyer can play an important role. I'll come back to that role later. Look at risk assessment tools if they are available, and make sure the encounter finds place in a safe place where it feels comfortable for people, and also get to provide aftercare. That is something, for example, that can be done in the Netherlands a bit better. The framework I mentioned already, the Convention on the Rights of the Child, Article 40, and the general principles, these general comments, and make sure that there's a concrete balance of interest in each case. And in addition to the rights angle, also look at needs. And that is something that I will mention the work of Tali Gal in a while. She is a researcher from Israel, and she also wrote a chapter in her book to combining the needs and rights of people, to be able to look at the different areas of work, the role of parents of the network, the role of the lawyer. They also all need to take into account that you're working with children and young people. So they need specific information if they are really young or if they have gone through severe cases or punishment or suffering. Then child-specific hearings are important. We have good examples at police level with those, but also in sexual violence cases, for example. Take in their circumstances and also use tools to work well with them. This needs rights model of Taligal, I mention a few more words about it because it's important to bridge the gap between the rights aspect and the welfare aspect. If you focus on needs only, there's the risk to focus on protection instead of empowerment. And we have come all the way with the emancipation of children's rights to also give children and young people also the right to empower themselves, to express what they want. And if you listen to children and young people, you see that they have often ideas of what they need and want. And rights can sometimes be seen as a platform, but we also need them to make a solid basis for what people need. Taligal also says if you use then restorative justice, there are 8 heuristics or principles that should be taken into account. Have a holistic view. Yeah, that's always important in this area. Make sure that every case, when you work with children and with the other party, that it's tailor-made. Every case is different, so maybe you need, instead of 1 meeting, to have 3 meetings. Make preparation and safety issues well thought of. See children as partners. That is also related to this idea of empowering them, but seeing them as partners in crime almost. Take them seriously. See participation also as a continuum and make sure that they can share their voice and ideas, and see restorative justice also as a goal, and make sure that you empower advocacy around them. If we use this all, how can restorative justice then be integrated within existing criminal justice systems? That is also what we maybe wonder about how that could happen in Turkey. And what we have seen here in the Netherlands as well. It came up in the 90s in my country as a sort of bottom-up initiative. Individuals and organizations had heard from this movement from experiences in New Zealand, in the United States, in the UK, but also our neighboring country, Belgium, was further with it than we were. And we started copying, we started piloting, and at some point tried to see how does it fit with our existing model. And we've seen that there are also thinkers in this area. Some have a more minimalist vision and other more maximalist. There are also this minimalistic vision is more that you need to keep restorative justice outside of criminal justice system and have it more as an additional option when people are ready for it. But it's also possible to integrate restorative justice within the court system. Sometimes in the end, with trying to make the system as restorative as possible. But it can also be that that you want to try to just have it as one of the options, next to the possibility as detention or community service, to be able to refer to mediation or a conference. Ideally, and that is what I for in my PhD and also in my book, is put it at the heart of the justice system. If you look at the family group conferencing system in New Zealand, for example, that is since 1989 a first option in the law, and it's based on a traditional system which they used with the Maori in their country a long, long time ago already, that issues are dealt with within the community, and they try to build that into the youth criminal system as well, especially since many children from Maori background ended up in prison. And that is since then a good working system whereby the network of both parties is brought into the court from this first stage. And their parties together come up with solutions for what has happened and how they want to look into the future. Now, around the globe, restorative justice is used in different forms and ways. There are also different laws in place, and but it is shown that if it's embedded in law, then the practice will develop, and you need to work on both sides. I would also state that bottom-up initiatives are still very important, but top-down, you need to have a government system that also believes and thinks restorative justice is important. And when we look then again at human rights standards, they actually, our governments have to. So that's also a lobby instrument you can use in your own country. The interesting thing is that it is these days a common practice in almost all countries in the world, but it's also a fact that overall figures of restorative justice encounters are still very low compared to the traditional criminal justice system, and there's still a world to win, to argue. What can be your own role as a lawyer? Yeah, you can refer cases, or you can speak with your clients about the possibility. If your system provides possibilities, then you can indeed tell them about that they can take responsibility. Yeah? If you are the lawyer of the young accused, then it's talking about taking responsibility, about victim awareness, about what do you want to reach. Is there also, when it's possible within your criminal justice system, you can also think of later moments when the young person has already has been sentenced and also has been either in prison or done a community service or so. It can still be questions like, what if this actually happened to him or her, and can I still have a conversation? So in the Netherlands, we have this possibility within the court, also afterwards, and that tends to work. If you are the lawyer of a victim, that can be an adult victim or a young victim, then also these kind of questions are important, like, what do you need? Is it enough to do a statement in court, like in some systems they have, and maybe also in your system, or do you really want to meet the other one, to tell him or her what has happened to you and how you experienced it? Yeah, it helps also to realize that if your case and your client steps into a restorative justice process, and you as a lawyer take a step back. It's then in the hands of the mediators, the facilitators who are actually taking over, and the parties themselves. We often refer to the work of the Norwegian criminologist Niels Christie, who actually said it's important to give the conflict back to parties themselves. And that is what we do in restorative justice. Yeah, they are the owners of the conflict. What do they want? It's about responsibility, it's about autonomy, it's about participation. But it should be well guided, and you need professionals to take care of how this is done, and that is done safely. Yeah, I just want to share a little bit of research we did the last 2 years together with Pierre Desom, the European Forum, and also my organization in the Netherlands, where we looked into the situation of specifically child victims and restorative justice in 3 countries, Romania, Greece, and Albania. And actually, the children themselves, they shared what they think is important. So I would like to ask if we can now share this little movie that I...
Rejideki arkadaşlardan rica edelim YouTube bu paylaşabilirlerse.
Okay, then I stop share my screen for a second.
Evet, şu anda görüyoruz.
Justice helps protects, heals, and empowers children victims of crime in their community. We do, and we wanted everyone to know it. We wanted children who have been victims of crime to have easier access to restorative justice practices.
We wanted children in contact with the law to know their rights and have them upheld. So, 2 years ago, Terre de Hommes Europe, Greece and Romania, the European Forum for Restorative Justice, and Restorative Justice Netherlands started a project, I Restore, Better Protecting Child Victims' Rights Through Restorative Justice, co-founded by the European Union. I Restore focused on 3 countries, Albania, Greece and Romania, and had 3 main missions: research, educate, advocate. The expert team produced 1 European review, had 3 national reports on restorative justice in cases involving child victims, so we know more about the situation in each country.
You can know more too. These publications are online for free. It emerged that, well, it's getting better, but the path is still very long. There are still a lot of challenges when applying restorative justice to children. One of the issues that we found out is that there are still many people working with child victims who still didn't know about restorative justice. The iRestore team started to train practitioners, lawyers, judges, decision makers. Every professional working with children is in contact with the law. And thanks to the free iRestore e-learning courses, more practitioners can continue to learn about restorative justice in child justice even after the project ends. And since nothing about children should be done without children, here we are. Our official name is Child Advisory Board Members, but Youth Advocates for Children's Rights is a good way to describe us.
This children's rights superheroes is also good. We don't mind. We had a child advisory board for each country, and we helped the shaping I Restore at every step of the way, shaping our experiences and opinions, spreading the knowledge among other kids. We even created our own awareness and advocacy material and events to make children's rights known to everyone and child protection available to everyone.
We learned a lot during these 2 years, but we think that the iRestore adult team also learned a lot from us. Then COVID hit, and we had to move all our activities online, but this didn't stop us. iRestore could not, on its own, fix everything and ensure that every child would have access to child-friendly justice based on restorative practices.
But together, we successfully built the capacities of practitioners and children in Romania, Greece, and Albania, and raised their awareness on what child restorative justice is. We moved forward, and we will keep advocating and working for every child victim in Europe until we reach a truly fair, child-centered justice.
Yeah, they can really express themselves well. We indeed learned a lot from them. Yeah, this one can be closed then. And to mention this e-learning course, that's also available for you if people in the audience are interested in our work. that if the PowerPoint has been shared, you can find the link to this. And there will be a next stage of this project, start this summer with part 2, and then also the Netherlands and Estonia will be involved, and maybe in the more long-term future also other countries can be involved. In my last part of this presentation, maybe there are any questions or comments right now. Is that the case? Then I can...
yes, you can share the presentation once again, Annemieke, if you can.
Yeah, I will do so, yeah. And if there are questions in the meantime, let me know.
Soru var mı salonumuzdan bu aşamaya kadar? Herhalde salon kendisini en sona saklıyor. Her şeyi öğrendikten sonra yani benim kafamda 10 tane soru var ama ayrıca soracağım herhalde. Burada hepsini soramam. Ama eğer soru varsa bu aşamada alalım. Bir beyefendiyi görüyorum. Buyurun lütfen. Mikrofonu konuşursanız tercümanımız sizi duyabilir. Böylelikle konuşmacımız da duyabilir.
Sayın Annemiek'e bir sorum olacaktı. Kahramanmaraş Barosu'ndan Avukat Hüseyin Gökot. Sorum şu, özellikle bu onarıcı adalet sistemi içerisinde mağdur ve failin yüz yüze gelme konusunda kendilerinin deneyimlerini, ne kadar istekliler ve bu isteksizlikler, yani gözlem olarak söyleyebilirlerse isteksizlik boyutları neye dayanıyor? Yüz yüze geldikten sonraki süreçlerde olumsuz olan sonuçlar veya olumlu olan sonuçlar. Yani mağdur ve failin yüz yüze gelme konusunu biraz daha hassasiyetle Sayın Annemieke anlatırsa memnun olacağım. Teşekkür ederim.
Biz teşekkür ederiz. Soruyu duyabildik mi acaba?
Yes, I did. Thank you very much, sir. An important question. If I'm familiar with face-to-face meetings and also why people would want to step in or maybe are not willing to take part. Indeed, we ask people if victims and offenders these days in my country, when they have gone through a criminal offense, at victim support, we start asking them, are you interested in taking part? And also for the accused at the police level, the first time already information is shared about this possibility. And indeed, there's also about 50% of the people does not want to have anything to do with this. So there is definitely a group that is not interested. We do see that if they get more information, they are more familiar with it. It helps if they have heard what other people have taken part, or if they have seen things about it on television, then this figure increases. And we do see in practice also cases where we asked it and they said, like, yeah, I'm willing to receive a letter, for example, but I'm not willing to meet him or her face to face. But in most cases where people are open for it, they do want to meet face to face, because that's what I've seen as a mediator myself, and also sometimes in court cases I'm doing as a judge, that they are actually open towards expressing their feelings and sometimes also expressing their anger at the other person. And it does well if you prepare it well. Is that enough of an answer?
Sanıyorum olmuş. Biz teşekkür ediyoruz. Çok güzel bir soruydu. Bir sorumuz daha var. Buyurun Özge Hanım. Yine mikrofonu beklemenizi rica edeceğim.
Avrupa'da bazı ülkelerde çok mesela şiddet içeren veya ağır vakalarda da arabuluculuğu uyguladıklarını söylediler. Mesela İstanbul Sözleşmesi bu konuda kadın yani aile içi şiddette, ev içi şiddet diyeyim. Ev içi şiddet içerisinde arabuluculuğun daha doğrusu alternatif uyuşmazlık yani çözüm yöntemlerinin uygulanmasını uygun bulmuyordu. Peki kendileri bu çocuk şiddetlerinde, ağır vakalarda nasıl bir yöntem izliyorlar? Yani buradaki şeyi nasıl? Mesela akran zorbalığı olabilir ya da işte çocukların arasındaki yaş farkından dolayı güç eşitsizliği, dengesizlik olabilir. Bu oradaki ince çizgiyi nasıl sağlıyorlar? Bunu merak ettim. Bir de şeyi sormak istiyorum. Mesela çocukların kendi hür iradeleriyle bu kararı verip vermedikleri ya da ebeveynlerin bu süreçlere nasıl bir katılımı sağlanıyor? Hem Avrupa hem de eğer mümkünse Hollanda'da bu konuda nasıl bir denge sağladıklarını merak etmek, öğrenmek istiyorum. Bir de son olarak orada belirli bir yaş kıstası uyguluyorlar mı? Yani bu çocuklara ilişkin sonuçta komitede bütün hani genel yorumlarında şunu söylüyor. Bu konuda evrensel bir yaş sınırından bahsedebilmek mümkün değilken bu ebeveynin katılımı katılmaması noktasında ya da rıza noktasında nasıl bir uygulama yöntemi izliyorlar? Onu merak ettim. Bilmiyorum ifade edebildim mi? Biraz karışık oldu.
Yok, çok güzel ifade ettiniz. Teşekkür ediyoruz. Bir soru hakkınızı 3 soru sorarak kullandınız. Teşekkür ediyoruz. Şöyle yapalım. Teker teker mi gitmek istediğini yoksa bütün soruları alıp hepsine mi cevap vermek istediğini soralım. Anemike Hanım'a çünkü bir el daha görüyorum. Tercümanımız beni duyabildi mi bilmiyorum. Anemike Hanım da bizi duyabildi mi onu da bilmiyorum. Buyurun.
I'm flexible, but now I recall still what she asked, so let me answer.
Please do so.
Indeed, the Istanbul Convention and other regulation in the field of intimate partner violence so have at first instance been a bit more reluctant towards at least forced mediation. And the kind of mediation and restorative justice encounters we are focusing on are actually voluntary processes. And also the people working in this particular field have moved more to an openness in putting things more also into the victim, the female victim often. What does she want? And it turns out that in almost all countries in Europe these days, mediation or conferencing in also these difficult and severe cases of rape or other forms of domestic violence and so on, sexual violence, can be dealt with through restorative justice if you really prepare well and have other safety things in place. If people themselves, they can at any moment step out of it. The only country that does prohibit it at the moment that I know of is Spain. But I have colleagues working in Spain that also try to work around it, and there's a lobby to change the law in this particular field. But with severe cases, you always have to have also professionals in place who can stop the process when it does not feel safe any longer. Yeah, so that is really, really important. Your other question related to children and parents. If I understood well, because it was a bit difficult to listen to the whole question with the translation and so on, I think it is important to share that in all cases where children are younger than 18 years of old, in principle, a parent is involved. If it is a case against the parent, or if the child has problems with the parents, then often it's they are looking for other caretakers or a person from the school or so to intervene, and so that's of course a balanced situation. Then there are if children and young people in the Netherlands are 16, 17, then you give them more moments also on their own, and a parent is more in the background. When they are younger, they play a more important role. So, and we really have time as mediators to prepare both parents and also children well, and also always take a bit of time with the child, him or herself, so he can more openly and freely. Yeah.
Sanırım bir soru daha vardı. Yaş kıstası. Belli bir yaş sınırı var mı? Belli bir yaş kıstası var mı? Bu süreçlerin yürütülmesiyle ilgili diye sormuştu Özge Hanım. Yanlış not almadıysam.
Yeah, often it's the age of criminal responsibility of a state. In the Netherlands, it's 12. So we do take up all kind of cases as from 12 years of age. The most cases I see, the young people are often already 15, 16, 17, and also our adolescence law can go up to 23, even if people have special needs when they are young. There are possibilities to use restorative justice outside of the criminal justice system, for example, in youth care, also with younger people. There you need this specific child hearings. We do have special forces within police to hear children who have been victims of domestic violence, for example. And also their restorative justice approaches can be used, but it is to be done within a broader system of care.
Mikrofonu bekleyelim. Bir ekleme yapmak istedi.
Sormak istediğim şu aslında, yani orada ceza ehliyeti yaşından itibaren karar vericiler çocuk mu, yoksa sürece dahil olan ebeveynler de bu karara bir etkisi oluyor mu? Türk hukukunda kıyaslamak için soruyorum.
Yeah, there is this difficulty if parents are absolutely saying no, and then you do have a problem in letting the child participate. But our system, if children are over 12 years old, then already our court system also starts hearing the young person. So if there is an argument, then there can still be a possibility that the child does want to take steps and the parent does not. And we try to also mediate between parents and children in that kind of cases. And we do see sometimes that other people around the child can take up a role, like a neighbor or an elder sister or somebody from the school. But of course, if parents are really very reluctant, then it is also sometimes difficult for the child to be involved, and he or she will be influenced by that kind of thinking, of course.
Cevap oldu mu bilmiyorum sorunuza. Sanıyorum bir sorumuz daha var. Ondan sonra devam edelim. 2 sorumuz var. Burada hatta 3 sorumuz var. Önü açıldı gerçekten. İsterseniz şöyle yapalım. Anladığım kadarıyla çok fazla slaytı kalmadı. Bir 5 dakikanızı daha rica edeyim. Ondan sonra bütün soruları alalım. Animik Hanım'a uygun olur mu? Soruları soranlara bakıyorum. Yani sunumunu tamamlasın, öyle soruları alalım diyorum. Çünkü çok az slaytı kaldı. Kafa sallandığına göre evet, tamam. Annemieke, please continue with the presentation, and then when you finish, you will get all the questions because we see a lot of questions coming.
Very good idea. I just want to reiterate or explain you a little bit more about our Dutch system. I explained some bits and pieces already, but yeah, our child justice system is taking care of the group between 12 up to max 23 years old. The penal code is covering both adults and has a special section for young people. This pedagogical approach and that children should be able to learn from their mistakes is really placed very strongly. We want rehabilitation and reintegration, like also Article 40 of the Convention on the Rights of the Child says up front. You see here a picture of one of our correctional youth facilities. it does look from the outside here as a nice house, but if you look a little further, you do see high fences, and also, I mean, it's really a close detention center, and it can be really harsh for young people to stay in such facilities. There is a new movement in the Netherlands to also work more with small-scale detention houses, where only 8 to 10 people are housed, and which can also be more open, so that they can go to school and come back there in the evenings. And so there are also all different stages these days and possibilities for reintegration. When we look at restorative justice, since 2011, we have a law, an article in our criminal procedural code, which actually says that the public prosecutor and the police need to provide information on restorative justice procedures. This article counts both for adults and for young people. But it also states directly that the court will take into account such an agreement. So when he or she decides about punishment or verdict, then it needs to be taken into account. And the practice of using mediation in penal cases at court level, so referrals by the public prosecutor or the judge, that has taken quite a development within the Netherlands. And since 2017, first it started with bias, but since 5 years now, it's a common practice in all of our Dutch courts. So that means that also at court level, mediation can be used. And if I then go back to the case study that I mentioned before, what happened here is that when Marco had to go to see the public prosecutor, she could say, I think you will maybe meet Davy again in the future. You're living in the same neighborhood. I think it's a good idea if you would settle things in a mediation. What do you think about it? That's a question that the public prosecutor will ask. Then the mediation office of the court will contact both parties and also talk to the parents. Then if they both say yes, two mediators are approached. These are specialized mediators in penal cases. They have gone through special education, and they also have regular trainings to be able to do so. And then if they all still say yes, then a joint mediation is set up within the court. So in this case, both boys wanted to meet. Their parents were there, and me and another mediator were taking care of this. And of course, then we start with very open questions like, okay, this is the setting. They need to sign a certain agreement in advance that everything is just what has been said stays within that room. So they only decide themselves what they want to share with the judge or prosecutor. We sign things about how the case is dealt with and about voluntariness, etc. And then they started talking, and Davy told about what he experienced. And interesting enough, he was also, even though it was really severe, the kind of injury he got, and it took him months to recover, and he also had to skip his year of school because he could not finalize. He was also able to reflect upon his own behavior, and he told Marco, okay, I did start. I was the one who first was waiting for you, and I started. But if you would have not having this knife with you, then it would be an ordinary fight, and we would probably have gone both our ways after this thing, because there were other friends around and they were already trying to take them apart. But since you had that knife, it all exaggerated it so much. And then also Marco was really telling why he had a knife with him. It was because his brother had been victim of their event before, and then he felt a bit scared. And he also was saying, like, I never used it before. I was not even planning, but I had it with me, and I felt scared. And so and it helped that people, that they were both listening and also seeing that it was quite an experience also for Marco, who had never done something like this, and he ended up in a closed facility and what he experienced there. And then, when all these things were shared, when parents had shared what they all had experienced, I mean, it's also, these kind of cases are serious and also emotional. So I had one of the mothers crying to me, and then the other mother started as well, so, and as a mediator, it's also sometimes difficult to all regulate this. But of course, we are trained in that, and we try to pay attention to it and also get it back to the conversation. And what next? What do you want now? In the end, in this case, some reparation was paid for a jacket that was broken, and then there was no insurance issue because all the things with the hospital were paid already. So financially, it was not a big thing here. What they wanted to discuss about, what do we do when we meet again? And we will meet in the streets, and they wanted to feel safe, both of them. And they said, okay, we will just greet each other. We won't become friends, but we will actually greet each other, and we will also make sure that our other friends will not interfere or make a new fight about this. So, and that really helped them. And then you can see that people are happily walking away. And also in this particular case, public prosecutor was able to take this into account and stop the case there, because she found that Marco already had stayed pre-trial detention for about 2 months, and that was enough. So you see that it can really work out like that. Okay. Yeah, we have more ways of restorative working in the Netherlands. I need to take into detail about these, because the time has ended. But if people are interested, we can send some material about about the school mediations, mediation, what we do in detention with restorative justice, etc. Mediation in criminal cases is only still 2,000 cases a year, referrals. Outside of the criminal cases, but still dealing with criminal cases, another organization, which is more about emotional recovery, is also about 2,000. But we do have a lot happening in the diversionary sphere and in neighborhood mediation. And if you count all these cases together, then we estimated about 40,000 cases a year. And yeah, I would like to end with this slide, that if you want change, also in the countries that we are working with in our European forum, we actually started sharing strategies for change. And I see that my organization, Restorative Justice Netherlands, had a lot of years of lobbying with our government, with our members of chamber, with politicians, to discuss how restorative justice can become more of a common practice, and also how it can get more position within our laws and regulations. And we even worked on a law proposal together with lawyers, together with people from the field, from research, etc. and that made us a real partner for our government officials who are dealing with making new laws. So they actually invite us now as experts, and that helps. And sharing these things among other people working in the field is something that we are doing within this Restorative Strategies for Change working group within the European Forum. And currently 10 countries are the countries that are mentioned here are part of this. In May, we will come together in Estonia and Tallinn again to discuss further ideas and share what on the national levels has been done and will be done for the future. And that brings me to the final question for you. What will be your change? Can you do something in your field? Is it something that you want to do more with? And then I would like to thank you for your attention. And oh yeah, a very last thing, we have our biannual conference in Sardinia, in Sassari there in June, and there's still some places available. We will be there with many international experts and participants, around 300. And there's also a training in advance given by Dominic Barter about restorative circles. Very interesting. So please have a look at our site. Thank you again.
Sayın Anamike'ye biz çok teşekkür ediyoruz. Gerçekten çok kıymetli bilgiler verdi. Hem Avrupa bölgesinde yapılanlarla ilgili ama ondan daha önemlisi bizim de ufkumuzu açacak onarıcı adaletle ilgili. Ben çok kısa bir dakika içerisinde söylediklerini özetleyip sırada bekleyen ve soru sormak isteyen sizlere sözü bırakacağım. Örnek olaydan bahsederek başladı sevgili Anamike ve aslında ciddi bir olay olmasına rağmen, bir bıçaklama olayı olmasına rağmen bu meselenin de çocuklar arasında uygun bir bağlantının kurularak onarıcı adalet çerçevesinde çözülebileceğini gösterdi bize. Onarıcı adaletin temellerinden bahsetti. Onarıcı adaletin sadece uzlaşma ya da arabuluculuk olmadığını böylelikle bir kez daha görmüş olduk. Çocuk adalet sistemindeki normatif yapının evrim geçirdiğinden de bahsetti. Çocuk Hakları Sözleşmesi'nde onarıcı adalet yok ama onun genel yorumlarında var. Demek ki giderek aslında geleceği konuştuğumuz bu günlerde bu söylemin değiştiğini de görüyoruz. İşe yaradığından bahsetti onarıcı adaletin ama bunun için bazı olmazsa olmazlar var. Bunun bir uzmanlaşma alanı olduğunu unutmamak gerektiğini ve çocukların katılımının önemli olduğunu bize hatırlattı. Diğer bir deyişle onarıcı adalet hak temelli olmalı ve sadece korumaya odaklanan bir onarıcı adaletin, güçlendirmeyi es geçen bir onarıcı adaletin çok çalışmayabileceğinden bahsetti. Avukatların rolünden ve Hollanda'daki sistemden bahsetti ki bir kez daha şunu da gördük. Bu bir usul değil, bu bir müdahale aslında. Çünkü aileyi, duyguları, orada katılan çocukların duygu ve düşüncelerini, ortaya çıkan öfkeyi, zararı yönetmeniz gereken ve aslında bu çerçevede bir uzmanlaşma müdahalesini gerektiren bir yapı. O yüzden bazı ülkelerde de bunun sadece bir usul kuralı olarak görmenin zararını görüyoruz dünyadaki farklı örneklerde. Nihayet herkesin herhalde bu konuda cezalandırıcı yaklaşımdan uzaklaşıp onarıcı bir perspektife sahip olması gerekiyor. Bu değişime ihtiyacımız var. Ben tekrar kendisine çok teşekkür ediyorum ve şimdi sözü Eylem Hocam başta olmak üzere, çünkü az önce tam heveslenmişti, onun hevesini kırarcasına sunuma devam ettik ve sonra soru sormak isteyen tüm katılımcılarımıza forumu açıyorum. Buyurun hocam.
Çok teşekkürler bu aydınlatıcı konuşma için. Hukukçu olarak hepimizin yüzünü çevirmemiz gereken bir yaklaşım, onarıcı adalet yaklaşımı 21. yüzyılda. Bundan sonra hep bunu konuşacağız gibi görünüyor. Ben de çok şey öğrendim. Aslında ben o kadar ismini çalıştım. Annemi Kiev Voltu ise soracağım soruyu hazırlıklı gelmiştim. bir makalesini okumuştum buraya gelmeden önce. Okuduğum makalesinden bir soru soracağım için kahve arasında sorarım diye düşünüyordum. Online olunca bir de siz o makalenize bir şekilde girip de temas edip oradan bahsedince arkasından bir de sevgili Özge konuyu açınca ben de cesaret buldum. Sanki kahve arasında soruyormuşum gibi algılayın lütfen. Bahsettiğim makaleniz Restorative Justice in Domestic Violence Cases, Best Practices article'ı, makalesi. Bu makalenin yazarlarından biri sizsiniz. Orada public crime ile intimate partner violence ayrımı yapıyorsunuz. O araştırmanın, o raporlamanın best practices, en iyi örnekler taramasının parametresi gibi bu ayrım. Bu ayrımda partner şiddetiyle, şimdi intimate partner violence diye İngilizcesini söyledim ki tercüman arkadaşlara kolaylık olsun diye. Diğeri de public crime. Bu ikili ayrım feministlerin kamusal alan, özel alan ayrımıyla ilgili yaptıkları bütün o feminist hukuk teorisindeki ilerlemeyi tersine çeviren bir şey gibi görünüyor ve buradan da feminist hukukçular çok eleştiri ileri sürüyor, eleştiriler geliyor. Nitekim Özge de oradan, o bağlantıdan çıktı, öyle geldi bana. Bu konuda hani evde olan evde kalır, devlet buraya girmez düşüncesine yaklaşmadan nasıl kamusal public crime'la intimate partner violence'ı ayırt edebiliriz? Tabii ki Gökten çok güzel söyledi. Sadece uzlaşma, arabuluculuk olarak ele almamamız gerekiyor onarıcı adalet yaklaşımını, ama her o mağdur ve sanığı yan yana getirdiğimiz durumda mağdura affet onu mesajını vermeden bu toplumsal cinsiyet temelli şiddete nasıl uygulayabiliriz? Böyle iki sorum. Biri feministlerin eleştirisi, kamusal alan ve özel alan ayrımını yeniden eskiye, geleneksel bakışa çevirme eleştirisi. İkincisi de nasıl daha tahakküm altında olan kadına barışmalısın, affetmelisin mesajını vermeden onarıcı adaleti sağlayabiliriz. Çok uzun oldu.
Oldukça ağır bir soru oldu gerçekten. Ben burada bir es verip önce Anemike'ye dönmek istiyorum. Çünkü cevap hakkı doğdu demeyeceğim ama kendisi toparlamak isteyebilir. Sonra da bütün katılımcılarımıza tekrar forumu açacağız. Buyurun.
Yeah. Thank you very much for this long and important question. I mean, I do see your point. It's been mentioned more often, and feminist lawyers have been criticizing this. There is, although within this feminist movement, also a change in the direction of giving, of asking parties themselves first. I mean, it has been quite a development to get these kind of awful partner violence cases more from the private sector to public sector, and to see them as crime that needs to be dealt with in court, and that is strictly forbidden, and so on. So it takes time and energy to be able to see it differently. I would also try to state very clearly that cultural sensitivity here is really important. So if people feel that kind of cases should not yet be dealt with in this area, or that it's too difficult, then you should maybe wait longer. We do have very good experience now, and we brought those experiences together in research. In Finland, in Austria, in Germany, they have like 25 years of experience where they see that often women are actually in favor of taking these kind of steps, and of course it should be done and should be checked if they are not being re-victimized again. All these things are definitely very important because that is ultimately what you don't want. So, but well prepared, well informed. Also, international standards are pleading for these kind of aspects, and then you can address this criticism in a human, in a relational, in a way. But know that in these kind of cases, you need minimum standards. You need to work very carefully, and you also need to stop this from happening when it's no good for both parties. For example, what we've seen in the Netherlands, often if you have cases of stalking, where the offender is still repeating his behavior a lot of times, then it's often not a good solution to use it. And there also mediators say, I'm not going to do this. And so we have within our system also several moments where we can decide, no, it doesn't feel good. Yeah, but tailor-made is the kind of word we want to use, we want to work with. And around the team, I'm also on this particular field with experts in the field of intimate partner violence. And that's also important, you know. You have to also reiterate that there's a big norm violation of norms and standards and human rights. I hope that answers a bit your question.
Çok uzun bir tartışmaya yol açabilecek. Belki de hocam sizin de Sasarya'ya gidip Annemieke ile bunu yüz yüze tartışmayı da düşünebilirsiniz. Ama gerçekten çok önemli bir konu bu. Toplumun da onarıcı adaletin tepeden inme bir şey olamayacağını bir kez daha gösteren bir tartışma. Aynı zamanda toplum ve aslında bütün devlet mekanizmasının da bu yaklaşıma sahip olmasının önemini de gösteriyor bir taraftan. Çünkü her konuda bir anda bu onarıcı adalet pratiklerine geçemeyeceğimiz de aşikar, farklı nedenlerle. Bana bir not geldi, bir an önce bitir, sırada bekleyenler var diye, ama soruları ben kestiğim için sıradan soruları almaya devam edeceğim. Buyurun lütfen. Yaklaşık bir 45 saniyede sorunuzu toparlamanızı rica ediyorum.
Peki, teşekkür ederim. Ben çocuk adalet sistemi içinde çalışmıyorum ama çocuk psikiyatri kliniğinde çalışan bir sosyal hizmet uzmanı ve psikoterapistim. Ve bir suçun mağduru olan çocuklarla çalışıyorum. Aynı zamanda hani kullanmak istemesek de suça sürüklenen çocuklarla da çalışıyorum. Ben şunu merak ediyorum, çünkü çocuk koruma sistemi hem çok multifaktöriyel bir konu, hem multidisipliner bir konu, hem de çok boyutlu bir konu. O yüzden de siz Hollanda'da bu kurumların bir arada koordine çalışmasını ya da tek başına adalet sistemindeki avukatlar, savcılar, hakimlerin bunu gerçekleştirmesi mümkün değil. Diğer meslek gruplarıyla bunu nasıl koordine ediyorsunuz ve nasıl işbirliği sağlıyorsunuz? Nasıl bir noktada buluşabiliyorsunuz?
Yeah, thank you also for that question. Very important to involve multidisciplinary team of people when you're dealing with child justice. Within our Dutch court system, we will have also this individual child assessment in place, whereby our youth protection board and also our youth care organizations are playing a big role. So as juvenile judges, we need to take those reports into account very seriously. And also when restorative justice is involved, then also the opinion of youth care professionals is used. At the same time, we also see that cooperation in this field can still be improved. That is also one of the outcomes of this Restore project. And another project that we did is called Focused, was really dealing with individual assessment of children and young people. And there we also see, and we're talking with people from probation, people from victim support, and they also recognize that they need to know more about each other's work and in these individual cases still need to be working more together.
Çok teşekkür ediyoruz. Bu da bizim sistemin kanayan yaralarından bir tanesi. Başka soru olmadığını görüyorum. Birazcık da dediğim gibi bir an önce bitir dediler ama tercümanımızdan da özür dileyerek kısa bir şey okuyarak bitirmek istiyorum. Bu satırlar 1940'ta yazılmış ve şöyle diyor: ceza hukuku suça karşı açılan mücadelenin muvaffakiyetini temin eden içtimai vasıtalardan yalnız bir tanesidir. Ceza hukukunun aczini, ceza kanunlarının suça karşı yegane çare olarak telakki edildiği devirlerde suç adedinin artması pek bariz şekilde ispat etmiştir diyor ve bu vakalara müsteniden önleyici tedbirlerin üstünlüğünü kabul etmemek elde değildir. Önleyici tedbirlerin lüzumunu hissettirdikleri sahalardan birisi de şüphesiz çocuk suçluluğu sahasıdır. 1940'ta bunu yazabilen bir hocaya sahibiz biz Türkiye olarak. Birçok ülkede daha onarıcı adaletin ya da cezai yaklaşımın aksinin tartışılmadığı yıllardan bahsediyoruz. Bu vesileyle hem Anemike Hanım'a çok teşekkür ederek bitirelim hem de rahmetli Profesör Doktor Faruk Erem'i bir kez daha bize ışık olduğu için analım. Teşekkürler. Çok teşekkür ediyoruz ve bu oturumumuzu burada sonlandırıyoruz. Tekrar çok teşekkürler sevgili Anemike. Yakın zamanda görüşmek üzere.
Okay, yeah, thank you very much, and enjoy the rest of your day.
Kendisine mi vereceğiz? Anemike, we have a gift for you. I don't know how we will hand it over to you virtually, but I will definitely send it to you. So I will take on your behalf.
Okay, thank you very much again.
The Union of Turkish Bar Associations planted a tree on your name in a forest. So, I mean, you have a part in Turkey now. So we will be happy to have you in Turkey soon as well, face to face.
Okay, now I'm looking forward. I'm going to see that small tree then, and I'm also looking forward to meeting you face to face.
Çok teşekkürler. Thank you very much. See you. We thank you very much, Anemike. Actually, it was a mind-opening presentation while we are discussing about the future of juvenile justice. You let us know about how we can integrate restorative justice practices. So now I am handing over your plate, and then I will send it to you, hopefully soon.
I'm really honored to receive this, and I'm really looking forward to working more closely with you, and also if you have the need of working together with the European Forum for Restorative Justice, I'm happy to facilitate.
Ben de onur duydum. Sizlerle ve Avrupa Forumu adına beraber çalışmayı dört gözle bekliyorum dedi. Çok teşekkür ediyoruz tekrar.